ideas about how to use animal law to protect wildlife. So we will hear first from Barbara Perez. Her article is entitled Hendry County's Best Kept Secret, Possible Legal Challenges to Non-Human Primate Breeding Facilities. Barbara received her JD with honors from Florida A&M University College of Law in May. During law school, Barbara was the recipient of several scholarships. She participated in the Criminal Defense Clinic. She served as the president of the Christian Legal Society and worked with indigent and underrepresented clients for Catholic Charities of Central Florida. The article Barbara will be presenting today was published this summer in the Journal of Animal and Natural Resource Law. And another article that she authored, Coexistence or Co-Destruction, Balancing the Competing Interests of Same-Sex Couples and the Free Exercise Rights of Religious Business Owners, is scheduled for publication this fall in the Trinity Law Review. After Barbara, we'll hear from Ashley Coons. Her article is The Perverted Ark, Failures, Successes, and Solutions to Protect the World's Rarest Creatures from International Trafficking. Ashley is a student at St. Mary's University in San Antonio, Texas, from where she'll graduate in May of 2019. Ashley was the runner-up in her school's 1L moot court competition, where she argued in front of the Texas Fourth Court of Appeals, en banc. I hope I'm saying that correctly. Her comment, Skinning the Cat, How Mandatory Psychiatric Evaluations for Animal Cruelty Offenders Can Prevent Future Violence, will be published in The Scholar, the St. Mary's Law Review on Race and Social Justice. Ashley's currently clerking at a wills and estates-based firm where she's helping compile a reference book of Texas animal law. And then finally, we'll hear from Judah Lieblich. His article is Minimum Size Restrictions Are a Problem for Fisheries. Is Litigation the Solution? Judah is originally from Perth, Western Australia, and was admitted to practice law there in December of 2014. He began his legal career at a large firm in Perth, where he worked in commercial litigation, land use, and environmental law before moving to Florida in 2015. Judah now studies law at Florida State University College of Law, from where he'll graduate in December. He's on the Journal of Land Use and Environmental Law and has interned with the 9th Judicial Circuit Court of Florida, the Florida Supreme Court, and the U.S. District Court for the Middle District of Florida. So with that, I'll let Barbara take it away.
All right, thank you. I'm very excited to be here, although I have to say I'm glad to hear that I'm not the only one that's cold. I'm from Florida, so this is freezing for me. All right, my topic is Hendry County's Best Kept Secret, Regulating Non-Human Primate Breeding Facilities as Industrial or Commercial rather than Agricultural Animal Operations. I'm going to talk a little bit about, and just briefly about, using animals in medical research. That's beyond the scope of my paper, but just the arguments for and against. I'm going to talk a little bit about the history of non-human primate breeding facilities down in Florida, the current governing legal framework, and my proposal, which is twofold, for regulating current and future non-human primate breeding facilities. So I'm sure not a lot of you, if any of you, have heard of Hendry County, Florida. It's a very small county down southwest Florida. And it's very small. Its population, approximately 39,000 people. But Hendry County is known as the nation's primate farming capital. Now, there are currently four non-human primate breeding facilities down in Hendry County. These facilities altogether can house up to 10,000 monkeys. Now, if you do the math, that's about one monkey for every 4 Hendry County residents. That's a lot of monkeys, especially for such a small county. Now, using animals in medical research, as you know, is very controversial. You have proponents who argue that, well, there have been many advances and many discoveries and cures for illnesses that are due to using animals in medical research. Things as discovery of the bacterium for tuberculosis, Parkinson's disease, diabetes. However, you have opponents that argue, well, the research does not yield the best results. And there are also alternatives to using animals, such as doing in vitro research or human research. Now, the topic of my paper is based on primates. And primates are not native to the United States. They're not native to Florida. They're native to Vietnam and China. Now, in the United States, every year, about 70,000 monkeys are used for medical research. Now, I don't know if you're familiar with these monkeys, but they're very unpredictable. They have unpredictable behavior. They can be very aggressive, especially when they mature. They can cause serious bite injuries. They're prone to the B virus infection and E. coli. So why is it that these primates are used for medical research? Well, proponents argue that the primates are so similar to people genetically that they show how diseases work in the human body. This list here, they argue that these advances or the cures for these illnesses and diseases have been due to the fact that they have been able to test on the primates. So polio vaccine, kidney dialysis, Parkinson's disease, and many others. So why Florida? Well, it all started back in around 1973. When a primate breeding company, Charles River Labs, leased 2 vacant islands down in the Key West. They figured that, of course, the tropical climate of the Keys was very similar to their native climate. The islands were empty, and so they figured that the water would serve as a barrier and the monkeys couldn't escape to the mainland. So what they did was they packed the islands with about 1,600 monkeys. And they let the monkeys roam free, and the monkeys started breeding, and then they would sell the monkeys to research labs. What happened was that the monkeys could swim, and so they started escaping to the mainland. They were not only escaping, but they also infested the waters. They destroyed the nationally protected mangroves, and they made a mess out of the islands. So Charles River Labs and the Board of Trustees down in Key West had to come to an agreement. And Charles River Labs had to take extreme measures to try to restore the islands back to their original state and to try to get the monkeys off the islands. They had to install chain link fences to exclude the monkeys. They had to monitor and meet the water quality standards. And they had to provide for a program that would phase out all the ranging monkeys. All in all, this took more than 15 years to get the primates off the islands. So fast forward to about 1998 in Hendry County. So why Hendry County? Well, the president of another primate breeding facility, Primate Products, found that Hendry County would be ideal to build a primate breeding facility. One of the reasons was that Hendry County is largely agricultural. There's a lot of land. Another reason is that the population there is used to working with animals. In Hendry County, there's a large immigrant population. They're used to working with animals. A third reason why they thought Hendry County was perfect was that Hendry County is about an hour and a half from Miami, from the port of Miami. So they could get shipments down to at the port and then quickly take them to Hendry County. And the fact that this was largely agricultural and far away from prying eyes was perfect. So the president of Primate Products met with the county commissioners, and they were able to get 640 acres of land to use to build their facility. Now, when they met with the Board of Commissioners, the Board of Commissioners didn't hold a public hearing, or they didn't give any type of notice to any of the neighbors. They figured that this was, or could be considered, a farm operation because they were dealing with animals. So because this is largely agricultural, they wouldn't need to give notice. This is one of the breeding facilities down in Hendry County, Panther Tracks Learning Center. And as you can see, it's a pretty big facility, and as you can see, surrounded by nothing by land. This is pulled directly from Primate Products website. And so I want you to notice that the kind of stuff that they offer, separate from breeding monkeys, they offer products such as serum and tissue, which they gather from the monkeys. They sell restraint devices. They offer primate boarding, health screening services, and they also offer, on the education side, they offer training and workshops. So PETA conducted an undercover investigation that kind of opened up this whole monkey farm thing down in Hendry County, and that's where people started noticing what was going on and how the monkeys were treated. So I do want to warn you, this video, it's a bit graphic, so I want to warn you beforehand. Could you please play the video?
Before they're shipped off to laboratories to be caged, tortured, and likely killed in experiments, thousands of monkeys are imported from abroad. Primate Products Incorporated, a dealer whose clients include the National Institutes of Health, has imported some monkeys captured in the wild and imprisoned them. Workers violently handled the monkeys, terrorizing them by grabbing their sensitive tails and lunging at them with nets. Some monkeys apparently became so distressed that their rectal tissue prolapsed and protruded from their anuses. Workers pushed the prolapsed tissues back in, held the monkeys upside down, and sometimes shook them. The facility sells some monkeys' blood and spinal fluid for profit. Piles of monkeys were left to wake up from sedation on bare concrete, trapped inside metal chutes. Monkeys are shipped to other facilities, including laboratories, in wooden crates barely any larger than they are, causing many of them intense distress and fear. You can help stop this. Go to PETA.org to learn more. Thank you.
What's interesting about this is that I live in a county right next to Hendry County. They're very small towns. And you talk to the people that live there or work in Hendry County, and a lot of them have no idea that any of these facilities are there. And it's interesting because Hendry County is the one that has the most facilities in the nation. So there are two cases that were very important in this monkey breeding facility issue. Number one was Stevens versus Hendry County. This was a case when in 2013, some of the neighbors in one of the small towns heard rumors that a big company was going to come in and build a big facility. They didn't know what the facility was going to be for, but they heard rumors that it was going to be like a monkey breeding something. That's what they heard. And so they emailed the Board of Commissioners, and they were trying to figure out, can you tell us what's going on? How come we haven't heard anything? Well, the county commissioners didn't respond, and so they learned that in fact there was 3 other breeding facilities in Hendry County. This would be the 4th one. And so the neighbors brought a suit against Hendry County, and they argued mainly 2 things. The first thing that they argued was that there was a violation of the Sunshine Law. The Sunshine Law states that any government official that meets for a decision-making capacity, they have to let the public know. They have to give notice, and they have to have a hearing where the people can come and hear and be heard. So they argued that that hadn't happened, and so there was a violation of the Sunshine Law. And they also argued that the monkeys are not domestic livestock because every one of these facilities is in a zoning where is agriculture. So they argued the monkeys are not domestic livestock. They shouldn't be under the umbrella of agriculture. However, the lower court and the Court of Appeals affirmed that monkey breeding falls under the definition of animal husbandry in the Hendry County Code. So the breeding facilities were able to stay. The second case is Tommy versus Primate Products. Mr. Samuel Tommy is a member of the Seminole Tribe of Florida, and he brought a case against Primate Products, which is one of the owners of two of the breeding facilities down in Hendry County. He argued two things mainly. One, that the activities separate and apart from breeding monkeys, the activities that we mentioned 2 slides before, are not agricultural. The education, the workshops, the selling of the serum and tissue, that's not agriculture. And his second argument was the monkeys constitute a nuisance. For this case was dismissed, and one of the reasons why the case was dismissed, the court found that in Florida we have a Right to Farm Act, and the Right to Farm protects farms from nuisance actions. However, and so the case was dismissed. However, my argument is that these are not farms in the first place because monkeys are not domestic. They're not domestic animals. It's not agricultural. However, that case was dismissed. So Hendry County has an ordinance, and even though there's 4 monkey breeding facilities in Hendry County, they have nothing in the books. They have nothing in the ordinance that regulates monkey breeding facilities. However, they do have this ordinance that talks about what is agriculture. And I'm not going to read all, but you can see the means the use of the land for agricultural purposes, including farming, dairying, etc. But they have this key phrase, animal husbandry, down in that ordinance. And so the plaintiffs, the neighbors, argued, okay, Hendry County has this ordinance and they have animal husbandry, but they don't define what animal husbandry is. So let's look at a common definition of animal husbandry and apply that. So a common definition of animal husbandry is the care and production of domestic animals. These monkeys are not domestic animals, so therefore they shouldn't fall under animal husbandry. Well, since the court found against the plaintiffs, the court said, well, back in 1998, when the first monkey breeding facility came and the county commissioners gave them permission, they set precedent. So we have to look at that. So even though there's no definition in the books, Hendry County decided that monkey breeding does fall under animal husbandry, and so we're going to go by that, and that's how they decided that. Now, while I was doing research for this paper, I found a similar case in Puerto Rico. Puerto Rico has had a long history with primates. Since back in the 1930s, monkeys were brought to Puerto Rico and they were bred, again, to sell off for research labs. However, of course, the monkeys escaped, and a couple of years ago, there was a campaign to get the monkeys off the island, but do so in a humane way because they were being shot to death. So Bioculture, another primate breeding facility, wanted to build in Puerto Rico. However, that was stopped even before construction started because the lower court and the Supreme Court affirmed that the context in which the monkeys are bred does not fall under agriculture activity. Instead, it is for industrial purposes. So they found the same reasoning. And one of the reasoning was, for agriculture, most of the animals in agriculture are for food consumption. In this case, monkeys are not for food consumption. So my proposal is twofold. Number one, it is to amend the Hendry County's Land Development Plan and Code to regulate non-human primate breeding facilities as industrial or commercial, because they shouldn't be agriculture. And number one, that a nuisance challenge may be brought to enjoin current non-human primate breeding facilities. So, because Hendry County does not have a clear definition of animal husbandry, I went around and I tried to see what other courts have to say about agriculture. For example, California court found that agriculture is the art or science of cultivating the ground, the art or science of the production of plants, animals, You get the idea. In Illinois court, the words agricultural purpose have been generally interpreted to carry a comprehensive meaning involving the art or science of cultivating the ground. The U.S. Supreme Court stated the question is whether the activity in a particular case is carried on as part of the agricultural function or is separately organized as an independent productive activity. And so my arguments are, well, these monkey breeding facilities are not agricultural. They're breeding monkeys for medical research. The monkeys are not being used for food, which is a goal typically of agriculture. They're offering training and workshops. They're providing biological products such as serum and tissue. They're selling restraint devices. They're offering other stuff like primate boarding, health screening that have nothing to do with agriculture. And so therefore, they shouldn't be sown in agriculture. And my second argument is a nuisance argument. This is pulled from a Florida statute, and it says, I want you to look at the words in red. To annoy the community or injure the health of the community shall be deemed guilty of maintaining a nuisance. So my argument is non-human primate breeding facilities are a nuisance. There's a risk of escape, especially down in Florida, hurricane season. In fact, during Hurricane Andrew many years ago, a lot of monkeys escaped and they caused chaos. The police ended up shooting some of the monkeys. Monkeys are known carriers of B virus or simian B. They're susceptible to pathogenic E. coli. They're aggressive. They're very unpredictable. They're typically housed down in Hendry County. They're housed in open-air cages, and they're exposed to mosquitoes who can bite the infected monkey and in turn bite and infect the human. And they generate large amounts of waste. So my proposal serves, one, to regulate. Using animals in medical research is going to be controversial, but at least this way we can regulate them how they should be regulated, not under an agricultural, but commercial or industrial, and that these people that are surrounding or adjacent to these facilities have a cause of action, and that would be a nuisance cause of action. So, thank you.
And we will do Q&A at the end, so we'll now hear from Ashley.
Hi everyone, I am Ashley Coons. I am originally from Nebraska, but I call San Antonio my home. I'd like to open with the quotation, just because I like quotations and I love Cesar Chavez. Kindness and compassion towards all living things is a mark of a civilized society. Conversely, cruelty, whether it is directed against human beings or against animals, is not the exclusive province of any one culture or community of people. And today we're going to be talking about wildlife trafficking. Just a show of hands, do people know what a pangolin is? Oh, yay, that's so awesome. So many times when I was writing this piece, I would have to Google it and show people what a pangolin is. But let's take a look. So the pangolin is this little guy right here. He is so cute, and they are the most trafficked mammal in the world. The International Union for the Conservation of Nature estimates that between 2004 and 2014, over 1 million pangolins were trafficked. And the primary reason for this is because pangolins are considered a delicacy in Vietnam and as well as China. But in China, for thousands of years, they've been used in traditional medicine, and they believe that it cures anything from possession by devils to malaria and deafness. So why do we care about pangolins? It shows that because pangolin populations are continuing to crash, it shows us that the current laws against trafficking are not working. There has been a substantial growth in the demand of pangolins over the years, and ultimately it represents a global crime syndicate based on the abuse and death of wild animals, valued annually globally at $20 billion US. The trafficking of animals and animal products has surged in recent years. There were nearly 50,000 illegal shipments of wildlife and wildlife products seized in the United States between 2005 and 2014, consisting of 55,000 live animals and 3 million pounds of animal products. The climate of international law does implicitly reject the inherent or moral value of animals in and of themselves, but the instrumental value of animals should be beyond their value as currency. We should value them as a life and not as simply a product. So although China and Vietnam are the largest consumers of pangolins, pangolin products, as well as tigers, rhino horns, ivory, the United States plays a huge role in the trafficking process because we serve as a hub, and we're the second largest market to China for trafficked animals in the world. Despite the severity and significance of such crimes, traffickers can receive a sentence as low as 6 months because, frankly, some judges don't care about it. One case that we will talk about is a teenager. He is 18 and smuggled a tiger cub across the border, and he got 6 months imprisonment for it. And when we get to the actual crime itself, you can see that he could have gotten a much harsher sentence, but the judge just didn't think it was worthwhile. Ultimately, I know that changing these laws is going to be very difficult because so many of these consumption practices are spanned in traditional medicine, or are based in traditional medicine, which spans thousands and thousands of years. But we do need to take a realistic approach and keep making those small steps because when we make because the man who begins to move a mountain starts by moving away small stones. So let's look at international wildlife laws generally. So the biggest treaty is CITES, the Convention on International Trade in Endangered Species. It protects 5,800 animal species and has 183 countries as parties to the convention, including China, the United States, Vietnam, Cameroon, and Uganda, which are all countries that are major players in the animal trafficking trade globally. Just to kind of go over what CITES is very briefly, it splits up species into 3 appendices. So Appendix 1 species are those most threatened with extinction and can only be traded in exceptional circumstances, so maybe scientific research, but essentially trade is illegal. Appendix 2 species are those which are not necessarily threatened with extinction, but trade practices must be controlled because unregulated trade is incompatible with their overall survival. And finally, Appendix 3 species are those that are protected in at least one country, and they've asked other parties to CITES for assistance in regulating trade. All 8 species of pangolins are considered Appendix 1 species, and other heavily trafficked animals in Appendix 1 include tigers, elephants, sea turtles, rhinoceroses, all of their species. Now, CITES does not provide any sort of punishment. It simply is sort of a regulation. So CITES founded the International Consortium on Combating Wildlife Crime, or the ICCWC, alongside Interpol, the United Nations Office on Drugs and Crime, the World Bank, and the World Customs Organization. And in 2015, the ICCWC orchestrated Operation Cobra 3. That resulted in 139 arrests of individuals in possession of prohibited animal products. And then we had Operation Thunderbird last year, which seized nearly 4 tons of pangolin scales and 8,000 live animals from 49 countries. So Interpol says that the success of these operations is demonstrative of what we can achieve through transnational law enforcement collaboration with the countries that these animals are being moved through. And that's going to be necessary if we want to see real change take place in the future. So looking briefly at China, one of my professors is from China, and he told me point blank, it is exceptionally difficult to find Chinese cases translated into English, but I was able to find some of their statutes, which are fairly harsh, but like the United States, we don't always see the harshest punishments being dealt out by these judges. So for instance, Chinese law has scales of punishment on offenses based on severity. Less serious offenses are punishable by a maximum of 5 years imprisonment plus a fine, whereas the most extreme acts can be punished by life imprisonment, death, and or forfeiture of property. Hunting of endangered wildlife is also a significant offense with a 5 to 10 year range of imprisonment for less severe crimes with over 10 years imprisonment plus forfeiture of property in severe cases. And interestingly, eating pangolins is criminalized, and you can be punished with up to 10 years in prison for doing that. However, we're not seeing a whole lot of this intense enforcement. One example is a 2016 case in which 2 individuals smuggling about $600,000 worth of pangolins into China were sentenced to 5 years imprisonment and fined just $30,000 each. In another incident, a man who killed and ate the last Indo-Chinese tiger was sentenced to 10 years in prison for eradicating the subspecies, and another 2 years was tacked on for illegal possession of a firearm. And these are both pretty extreme cases, and we're not necessarily seeing those more harsh punishments. And part of that is just due to corruption, as well as general difficulty, especially in rural China where these practices are strongest. Looking at African nations, they do have anti-trafficking laws as well, but they face similar problems just because of poverty, lack of resources, and of course corruption. To look at a few laws, South Africa has the National Environmental Management Biodiversity Act that was created in 2004 to protect endangered species from poaching and trafficking. It creates a punishment of up to 5 years imprisonment and a fine of up to 100,000 South African rand, equals about $11,000 US. The Central African Republic has a similar law, and they issue a fine of up to 1 million francs, about $2,000 US, and 5 years imprisonment for killing or mutilating protected animals. Kenyan law is really interesting because it features specific and general punishments depending on what animal has been killed. So for killing an elephant, leopard, or rhinoceros, it's punishable by a fine of 40,000 Kenyan shillings, about $400 US, and up to 10 years imprisonment. Whereas killing a bongo, giraffe, oryx, other ungulate is punishable by half the fine and half the prison time. But again, enforcement of these laws is very difficult due to lack of resources, poverty, and so on. So let's look at laws in the United States. The earliest is the Lacey Act, which was passed in 1900, and it was meant to enlarge the powers of the Department of Agriculture by prohibiting interstate transportation of animals killed in violation of local law or for other purposes. So it's pretty broad. And this works alongside the Endangered Species Act, which is to protect endangered flora and fauna from exploitation. So under the Lacey Act, a felony violation is punishable by a fine of up to $20,000 and a maximum of 5 years imprisonment. Misdemeanors are punishable by criminal violations of the Endangered Species Act, fine of $25,000 to $50,000 and 6 to 12 months imprisonment, depending on the crime that was committed. So Congress really wanted to hit these criminals in the pocketbook because if you look at their notes on why they have such a high fine in comparison to prison time, they're showing that the main motivation for doing these crimes in the United States is money. So if we can create a huge financial deterrent, ultimately we should see that decrease in crime. However, as we get into the case law, we'll see that isn't necessarily the reality. Finally, there's the Eliminate, Neutralize, and Disrupt Wildlife Trafficking Act, or the END Act. That was passed in 2016 to make wildlife trafficking offenses equal to drugs and armed trafficking offenses. This is huge. It creates a maximum fine of $250,000 and 20 years imprisonment. However, this only applies to living animals, not parts and products. So we're seeing some states trying to fill in the gaps. So New Mexico introduced a bill that would impose civil and criminal penalties on traffickers. That will be subjected to a misdemeanor charge and a fine of up to $25,000 or 3 times the value of the smuggled item, whichever is greater. Again, trying to hit them in the pocketbook. Arizona and California are also attempting a similar approach by focusing on inclusive laws that focus on removing the incentive to traffic animals and their products. Those bills haven't been introduced yet, so I don't have a lot of information on them. So getting into a little bit of case law, we have United States versus CAP, in which a man had basically this tiger and lion breeding operation and would produce products based on their deaths, so skins. teeth, so on. And he was sentenced to about 4 years imprisonment, followed by a 3-year supervised release, a $5,000 fine, and 300 hours of community service. So he got off pretty easy despite having an entire business based around the exploitation of big cats. So unfortunately, while we have these harsh punishments, again, we're not really seeing them being enforced. And then in 2018, I believe in March, we had the 18-year-old trying to smuggle a tiger cub. And there is less incentive to place a low-level offender in 20 years because a lot of the times poverty is driving these crimes, especially in Mexico and African nations. But it is disheartening to see judges not really take this seriously when we have the ability to introduce those high fines that can serve as that deterrent as well as the imprisonment. So what can we do in the future? We could look at the International Criminal Court, or the ICC. The ICC is kind of considered the court of last resort, so we probably aren't going to want to start here. But the interesting thing is that in 2016, it increased the definitions of crimes against humanity to include environmental destruction, particularly in the form of land grabbing, which is large-scale acquisition of land by foreign persons. And this can help protect endangered species environments because obviously we want indigenous persons to have their livelihoods protected, and a lot of their livelihoods include so specific animal species that can be heavily trafficked. So by having ICC jurisdiction and investigating wildlife crimes alongside those environmental destruction crimes, we could have an international court in that area. Another possibility is to focus on international cooperation through economic rewards. So by creating trade incentives, you can create international cooperation. And we saw this happen with the 1961 Foreign Assistance Act, which rewarded countries that took efforts to reduce their drug transit by diversifying their economies. And conversely, countries that failed to make changes required on the act were punished by not giving them foreign assistance. We also saw the Andean Trade Preference Act in 1991, followed by the Andean Promotion and Drug Eradication Act in 2002. And these programs were successful, and it showed that the United States was willing to come in and help diversify these economies by providing alternative crop development in Bolivia and Peru specifically. Because a lot of these countries were growing coca to make cocaine, and by showing them that you can make other crops, grow other crops, and still have a workable economy, you don't have to go into the drug trade. So a similar program can be used in developing nations that produce products derived from pangolins, elephants, and rhinoceroses, because a lot of them are poor and lack economic diversity as well. Yes, thank you. Yes, thank you so much. And ultimately, what we would see from that is deterring poor individuals from turning to crime in the first place. Finally, the most important solution is educational programs. And these would work to decrease the demands for the animals in question to begin with, and simultaneously making the would-be offenders aware of potential punishments should they break the laws. So in China and Vietnam especially, where demands for wildlife products are some of the highest, programs that decrease demand are nearly as important as programs that punish. China has long used educational programs, but they don't seem to have disrupted the demand for pangolin or other animal products. But again, Chinese traditional medicine has taken place over thousands of years. This isn't something that's going to change overnight. Sorry.
Wish I had a joke to tell or something so you can relax and have some more.
However, educational programs in sub-Saharan Africa are proving to be very successful. While human growth is exponential, creating a lot of impoverished individuals, educational programs send a clear message that animals are worth more alive than dead. We have ecotourism, which encourages the conservation of animals, in which they show that foreigners are willing to pay a considerable amount of money in order to see these animals, such as the lions, the elephants, the rhinoceroses, that normally would be poached. It does somewhat narrow the scope by primarily focusing on elephants, rhinos, and lions, but ecotourism can always expand, and stronger laws similar to those in Kenya, which really identify what is being poached, what is considered valuable in terms of animal trafficking, can help to serve that purpose to deter once and for all. So looking to domestic changes, we would want to see ultimately higher punishments under federal laws, under the Lacey Act, and so forth. But what we would like to really see is state laws to implement mandatory minimum punishments for these offenders. So, for example, we would have a 1-year imprisonment for low-level offenders who may not have killed or harmed the animal in some way, but it would make somebody rethink their involvement in being involved in that offense in the first place. A financial deterrent may not necessarily be the best for these low-level offenders. They probably aren't going to have a lot of money in the first place. That's why they're committing the crime. But 1 year imprisonment, that's 1 year of your life that you are not getting back. That should be a fairly significant deterrent. For high-level offenders who kill, torture, otherwise severely harm the animal in the process of trafficking, the minimum punishment should be 5 years imprisonment. And the reason for this is to kind of unify what we have for state laws already. So in Texas, we recently amended our state cruelty law to punish animal cruelty between a minimum of 2 and a maximum of 10 years imprisonment. California law also has a maximum punishment of animal cruelty offenses for 3 years, whereas New York has animal cruelty offenses to be punished by a maximum of 2 years. Having a flat punishment of 1 year for those low-level offenders, plus a 5 years for the severe offenders, can kind of create a meshing of these state interests and kind of show that, yes, the states do care and we want to have sort of a unified punishment under this. So there are a lot of issues that I really wanted to cover in this paper, but I just didn't have the time. One of them being the evaluation of the mental health in relation to certain acts of cruelty. That is huge for me. I want to know why people are doing this in the first place, and I think that would really help with the educational programs. Of course, there is the issue of what do we do with these animal products after they're seized? Do we destroy the animals? Do we destroy the products? Do we try to rehabilitate them? Can they be rehabilitated? What are the ethics of keeping these animals in sanctuaries or even zoos? And then, of course, there is the issue of the pet industry, where a lot of these animals are being trafficked, parrots especially. As you can see in this picture, these are cockatoos that are being imported specifically for the pet industry, and as a bird lover, it breaks my heart because those birds are going to come out traumatized, and probably people are going to buy them, have it for a year, and then abandon it. And we will have some questions later on. Thank you so much.
Hi everybody, I'm Judah Lieblich. I wrote my paper on minimum size restrictions, which are a form of fishery management regulation, a regulatory tool. And today I'm just going to give you a really quick overview of my paper. I'm just going to explain to you what minimum size restrictions are, why they are dumb and stupid and achieve nothing and do more harm than good, and how litigation can be used to get rid of them. I originally wrote this paper thinking I was writing an outline for some future litigation. So while I run through it, I'd like you all to think of yourselves as my co-counsels on this, and I'm going to run you through the plan of attack. Step 1, know your enemy. This is a good example of what minimum size restrictions are. This is taken from some Florida state regulations, but it's the same idea for federal. Basically what you've got is the species in one column, the length limit, the minimum size restriction in the next, and the bag limit. If you've ever heard of catch and release fishing or practiced catch and release fishing, minimum size restrictions are what underpins catch and release fishing. If you catch a fish which is smaller than the length limit outlined over there, then you have to let it go. If you catch a fish that's larger, you can take it home and it counts towards your bag limit. Now, these regulations are incredibly prevalent. They're in every major fishery in America, and they're all over the world as well. One of the reasons why they're so prevalent is because they're so popular. They're seen as a conservation method. They're seen as something which is ethically good to do and sustainable. It's a good way to release young fish. They deserve to live longer. And it's popular amongst recreational fishers because they get to fish for as long as they like. Minimum size restrictions don't restrict fishing effort at all. All that they require that you do is throw back small fish. So a recreational fisher can fish all day and bring back 2 or 3, whatever the bag limit is, larger fish, and that is seen as reward for effort. Now, what is the weakness of minimum size restrictions? It's their main problem. Minimum size restrictions operate on the assumption that the released fish live, but as is probably already obvious to you guys now, and which has been proved by a lot of scientific research, they mostly die. Whether it's from predation and exhaustion from being pulled up to a boat, whether it's from barotrauma, which is a condition where the fish's swim bladder ruptures while they're brought up from the depths, and then when they're released, they're unable to get back down because their swim bladder is inflated, or whether it's just from the harm that's caused from unhooking a fish and handling a fish. They can catch diseases from us and things like that. Whatever the reason is, catch and release fishing leads to the death of most of the released fish. Now, it varies by species, but that's the main takeaway from that. That leads on to the second point. Catch and release fishing encourages us to take large fish out of a fishery and leave small fish. Now, what underpins that is the assumption that we're going to let fish grow to be big enough to undergo one reproductive cycle, to spawn for 1 year, and then the size they are after that year, that's what is set as the minimum size. The problem is that the larger a fish is, the better it is at reproducing. So 10 smaller fish might be able to reproduce at the age they are, but they probably won't be as effective as one large fish. And when you're increasingly telling people to catch larger fish and take them out of the fishery, you're essentially removing the best reproducers from that population. That then bleeds into the third issue, which is the effect on the populations themselves. Not only are you removing the best reproducing individuals, but you're also leading the fish population to respond by growing smaller. The fish will end up maturing at an earlier age. They'll end up sexually reproducing at an earlier age. And what that means is, as we've already seen, the smaller the fish are, the worse they are at reproducing. So you end up having a population which is less able to sustain itself and which is more volatile. Minimum size restrictions originally were set in the 1800s and 1900s. I've got a good quote from a Fisheries Management in Australia book written in 2008, where it says that the preferential removal of larger individuals was initially introduced in the 18 and 1900s without any sort of scientific knowledge whatsoever. It was introduced based on the size that was acceptable for consumers for the commercial fishing sector. And that essentially is minimum size restrictions in a nutshell. They were not introduced as part of any sort of scientific forethought or planning. Now, when I was in Australia, I worked briefly in a government internship with the Western Australian government. I was asked to look at size restrictions as a part of a broader government effort to reassess all of their fishing regulations, species by species. They already had some idea, this was in 2011 and 2012, that minimum size restrictions were a bad way of managing things. Since then, they've undergone a species by species assessment. One of their working papers, this is a quote taken from it, "There is no sustainability benefit for a size limit if released fish have a low rate of post-release survival." And that's really it. What they've done is what I like to call the lazy Australian method of fixing things. As you can see there, they've just removed the minimum size restrictions altogether. For a lot of those species of fish, the minimum size restrictions are now gone, and whenever you catch one of those fish, no matter what size it is, you take it home and it counts towards your bag limit. Now, it doesn't eliminate the harm of fishing in general, but what it does do is it says if we're setting a bag limit at 1 or 2 or 3 or 4 fish, we know what's being taken out of that fishery by a certain number of licensed fishers. If someone is sitting in their boat catching hundreds of fish and they only take home 2, but they're releasing 98 and 60 of those die, it's not only not monitored or enforced, we don't have any record of it. Potentially distressing photo coming up next. It's of fish trawling in Norway, but it's actually a positive sign. What the Norwegians have done is significantly more complicated than what has been done in Australia. They've introduced a complete discard ban. Now, what that means is normally when you see a photo like that, that fishing trawler would be looking for a specific target species. They would sort those out and remove them from that hole over there, and then they would throw everything else back. And most of the fish that they throw back, if not all, would be dead. In Norway, that practice is now illegal. Everything there has to be kept. What that means is target species are having less of their numbers taken, and new industries have grown up in Norway, and the EU is introducing these sorts of regulations now too, to either make these fish marketable, use them as fertilizer, or whatever. But it has actually led to far greater sustainability of European fish stocks. So what do we do in America, where none of this has been undertaken just yet? Well, I started by telling you that I think litigation is the way to go. But to understand why, we need to understand a little bit about the legislative framework, and I promise I'll be as quick as possible. But the Magnuson-Stevens Act governs fisheries, federal fisheries in America, and that's what my paper mainly talks about, is federal fisheries. Under the Magnuson-Stevens Act, the US is divided into a number of different regions. Each region then has a council appointed, and that council will set the fisheries management plan, which is the FMP. The FMP is, if you think back to those cutouts of Florida's minimum size restrictions, the FMP sets those. It sets all of those sorts of requirements and regulations. So that is what you're trying to influence, or if unsuccessful, you're trying to sue to change. Now, the Magnuson-Stevens Act, when it was introduced, the original idea was that all the stakeholders, which is recreational fishers, commercial fishers, and environmentalists like us, would all sit down at a table and have feedback and have their own input, and then that would influence the regulations. And there's actually a requirement that the councils consult all these different stakeholders. That has eventuated to some extent, but mostly it has not been successful. And the reason why I'm cynical that it would be successful in this case is because of what I've already said, that minimum size restrictions are incredibly popular. They're very popular amongst recreational fishers, and they are popular amongst commercial fishers to a certain extent as well, because it means they can avoid other more prescriptive regulation. So that being said, any sort of litigation always has to start with stakeholder input in this case. In Greenpeace v. Franklin, the court said that although it expressed no opinion as to Greenpeace's failure to engage in the stakeholder input level, it could not, sorry, one second. The court nevertheless concluded that it could not characterize the defendant's actions as arbitrary, that's the defendant being the agency, for failing to consider views never presented to it. So they're already alluding there to failure to set up for Chevron Step 2, but what you can see is that if you're not getting involved at the stakeholder level, it's definitely going to undermine any future litigation you try to undertake. All of that being said, there are 9 national standards which were introduced into the Act. They've been introduced at a haphazard rate, a few here, a few in 2009. And this is where litigation can really, this is the hook that we can use to bring litigation against FMPs to change them, because none of these national standards are consistent with each other. You've got National Standard 1, which requires the prevention of overfishing, National Standard 2, which says that regulations have to be based on science, and then you've got something like National Standard 8, which says that to the extent practicable, you need to limit the impact on fishing communities and limit the economic impact on fishing communities of regulations. So as you can see, those are not consistent. And it's those frictions and the fact that these FMPs will never actually meet all of these national standards, which allows us to bring litigation. So no litigation has ever actually been brought, no litigation has ever actually been brought to remove minimum size restrictions. So we're just going to have to try to piece together what we can from similar arguments. First two steps in any environmental law litigation, standing and then deference. I'm not going to get into standing too much because it's boring and you all know the basics. But I will just add one quick thing, which is that interests in fish populations are always overlapping. And the courts have recognized that when it comes to standing. So when a commercial fisher sues an FMP and says this FMP breaches the national standards, that FMP doesn't need to have a regulation that imposes some sort of requirement on the commercial fisher. In fact, in this case up here, what happened was the commercial fisher sued an FMP for having too lax rules on recreational fishers. So that kind of overlapping standing helps anyone bring cases. As to deference, again, I don't want to get into it too much, but rest assured there have been cases that have gotten past Chevron Step 2. There have been cases of arbitrary and capricious FMPs. Briefly update on this, we have Justice Gorsuch, who is an enemy of Chevron deference and is going to try to get rid of it at any cost. If you've read his Epic Systems case, then you'll know that he's waiting for his opportunity. The indications are that Kavanaugh leans more towards where Chief Justice Roberts sits in terms of believing Chevron should be limited but not removed. But it's definitely going to be touch and go for the next few years, and I wouldn't rely on Chevron's remaining in its natural state for much longer. And basically, this could be a bright spot in what could otherwise lead to the removal of a lot of good regulation. So like I said, there's never been any case brought seeking the removal of minimum size restrictions. But there have been a few brought which sort of touch on this issue. In Flaherty, there was an FMP which had some effort to reduce bycatch. It contained a cap on one species. It contained a requirement that part of the fishery be closed for 4 months. And when this FMP was sued under National Standard 9, the court stated that these measures, even though they reduced bycatch to some level, did not sufficiently reduce bycatch. So National Standard 9, I probably should have started with this. National Standard 9 is the reduction of bycatch, and it requires bycatch to be reduced. Now, bycatch is whenever any fish which is not targeted is captured and dies. Now that is like that photo I showed you from the deck of the Norwegian trawler. All the fish that weren't targeted and died are bycatch. Now minimum size restrictions necessarily have bycatch. It's called regulatory bycatch. Whenever you throw back an undersized fish and it dies, that's regulatory bycatch. So this national standard of bycatch provision is clearly implicated by minimum size restrictions. Next case, Pacific Marine Conservation Council v. Evans. The court found that the agency breached Magnuson-Stevens Act by failing to consider other potential bycatch reduction methods, one of which was a cap on discards. Now this requirement that the agency consider other potential bycatch reduction methods is where we can get a hook into this sort of litigation, because the removal of minimum size restrictions is a bycatch reduction method. The other good national standard that we can sue under is National Standard 2, which is that FMP regulations must be based on the best scientific information available. As I've already said, most of these regulations, when it comes to minimum size regulations, most of them are based on on the size that a fish is when it's able to sexually reproduce. But there's no population data, there's no study that can support the implication that minimum size restrictions actually improve sustainability. And in fact, the opposite has been shown to be true. So in Hadawa v. Evans, you had there an FMP which banned trawling in favor of long line fishing. Now, that might appear to people who know what those are. Long line fishing is fishing for specific species on long lines which have baited hooks on them. And then trawling, we've already seen a photo of that. So you would think long line fishing is necessarily better and that there wouldn't be a problem with the FMP banning trawling. The problem was that this regulation change was undertaken because there was a compromise reached between two different commercial fishing groups. What the court said was the agency can't base its decision-making on these sorts of compromises. They can only base it on the best scientific knowledge available. And this goes back to why minimum size restrictions existed in the first place. Remember, I quoted that book which said that they were introduced in the 1800s and 1900s without any knowledge of what sort of an impact they would have. If we're forcing the agency to justify the use of minimum size restrictions in court, then they're not going to be able to find much supporting evidence. So there hasn't been any cases which actually directly seek the removal of minimum size restrictions, but there have been a few which mention minimum size restrictions. Now, Southern Offshore Fishing Association v. Daly, in that case, there was a removal. A removal of shark species from the fishery. The agency stepped in to introduce a cap on the number of sharks that could be removed from the fishery, and then the Fishing Association sued the agency for doing that. The court sided with the Fishing Association, and the court said they shouldn't have considered a cap when they could have introduced minimum size restrictions. Now, that really sums up the traditional view of minimum size restrictions in court. They're seen as this conservation effort, effectively lip service to environmentalists and conservationists. But when it actually comes down to the raw numbers of fish being taken out of a fishery, they give the agency license not to have to reduce that amount. Ocean Conservancy v. Evans is a slightly different case. In this case, the FMP actually suspended minimum size restrictions. This suspension of minimum size restrictions was then challenged by environmental groups. And the environmental groups wanted the minimum size restrictions because they saw them as a conservation effort. The agency then was in the position of having to argue in favor of removing minimum size restrictions. And that's why this case is just pure gold, because the agency is actually making the exact same arguments that I am. The agency said that the emergency rule suspending the use of minimum size restrictions satisfied National Standard 9, which is the one I said we should sue under. They argued that the minimum size restrictions actually increase dead discards of sharks, which are under the minimum size, and lead to increased fishing effort for fishers who are chiefly catching undersized sharks, resulting in overfishing. So there, in a nutshell, is exactly the argument we're trying to make. So I would definitely hold on to that one, co-counsels. Lastly, any environmental litigation, throw NEPA in. Why not? Look before you leap is especially useful when agencies have been leaping using minimum size restrictions for decades and no one really knows why. And then lastly, the current atmosphere. We're clearly in an atmosphere that politically favors the removal of regulation and the removal of deference. Now, that is probably overall not a good thing. But at the end of the day, I think that there are many instances where regulation removal could be beneficial. I think that this is one of those areas where it could be beneficial, and I think that litigation would be the way to do it. Thank you.
Questions?
I will go to you. Questions?
I can just highlight in the meantime while people are thinking of their questions how interesting it is to hear all of the ideas that you've presented in these different contexts, which are really applicable, I think, in animal law much more broadly. Like the idea of needing laws to catch up to the science, like Judah mentioned, and as Ashley mentioned, like having the law reflect the inherent value of animals as opposed to just their like commercial or property values we see in lots of contexts. Or as Barbara talked about, having animal exploitation industries regulated as industry as opposed to agriculture. That's something that comes up in the factory farming context. So I think it's been really interesting to hear the application of those principles, which we see, I think, across the board in animal law in each of the contexts that you discussed. So thank you.
Hi, my name is Delana. Thank you for speaking and sharing your research. This question is for the middle speaker. I'm sorry, I forgot your name. I was wondering what evidence you're citing to show that harsher punishments, specifically longer terms of imprisonment, will actually deter people from committing these crimes.
So that is not something I really touched on in this, but in my other article, it's really been focusing on the fact that people don't really think it's something serious. They don't really think about it as being a crime that the government is going to take seriously. And I think that by having those educational outreach programs and showing people that, yes, you should get in trouble if you do this, there is a serious consequence for these behaviors. That's kind of what I'm getting at. I'm sorry I don't have a more direct answer to your question. That's entirely on me, but I hope that helps a little bit.
That's okay, thank you.
And I will say that all of their papers are on our website, so if you did want to check any of them out, read them, they are available. I'm also happy to send them. If you can't find them online, just email me and I can get them to you.
For each of you, did you have a very specific kind of audience in mind when you were writing these of who you're hoping would read them and maybe act on some of your ideas, like more, not just general, but like specifically?
So my topic was very specific because it was for Hendry County down in Florida. So, and my proposal is very specific for Hendry County to either amend or add regulations to the ordinance. So it was very specific for that county, but there are about 17 non-human primate breeding facilities in Florida. In the United States, and so I think it applies to all of them. So for me, it was specifically for Hendry County, Florida, but it can also apply to. So the audience would be, the county commissioners of whatever counties or local government where those facilities are found.
So I was kind of the opposite in that I tried to make my audience very broad. I think in my mind, I was really wanting to address judges because that's where I felt like a lot of the enforcement issues were coming from. But I also wanted it to apply to professors and to activists, just anybody who reads it to be able to see, okay, there is an issue. How can we get involved? How can we do something? And I think that, for instance, educational programs and seeing how can we get involved with educational programs or like funding those resources. I want people to be able to read my pieces and feel like they can do something about it, but specifically, I think I was addressing judges and people who are able to make those more tangible changes in the law.
I think that I probably talk a big game about litigation, but I think that the real outcome of my paper, or at least what I hoped while I was writing it, would be that people would be more educated about these regulations and how dumb they are, and hopefully that would lead people to change their minds. I think that in the scientific community this stuff is generally known, but not so much in the legal community.
I think we have a question up here, Priscilla.
So this goes to kind of like the traditional uses of a lot of these problems based on fishing, generations of fishermen, and then we go to zootherapeutic uses in Southeast Asia, where these are just generations and generations of people practicing these beliefs, and they strongly believe them, just like any other religion or belief out there. I wrote a paper similarly looking at CITES and CMS about the substitution of lion bones for tiger bones, specifically in Southeast Asia. This summer, and My biggest problem was trying to figure out how you connect the dots between the law and the education there, and how you can kind of make those work in conjunction to succeed in the overall plan. Because you can start getting rid of pangolins, maybe they'll figure out a substitute animal that's similar, and problems like that. So I was wondering if you guys had any comments on that.
Yeah, do you want to go ahead? Okay.
Yeah, that, I think what you outlined is something that I really struggled with in my paper. I mean, it was very hard to find any sort of resource which explained why minimum size restrictions were brought in the first place. They've just kind of always been there, and now they're just sort of the furniture. In terms of closing that gap, it's incredibly frustrating. Education is obviously necessary, but I don't think it's going to get us all the way there, and that's why I thought that litigation could actually work. You could never have enough litigation to remove minimum size restrictions. There's so many. I mean, even that graphic I showed you of the ones in Florida, that's only a few of the species that have them. You're probably a 10th, and you'd have to sue for each species to have it removed. So even the idea behind the litigation would be to educate other regulators.
I think I would, just going off of what Judah said, for me too, it was really difficult to see like what evidence we have in Southeast Asia of these educational programs working. And I think that it does ultimately come down to the fact that we need those enforcements alongside the educational programs, because unfortunately, educational programs aren't going to change everything overnight, and especially on its own. If people, especially one thing I was surprised to see is that it's a lot of times very wealthy businessmen who will be going out and they'll say, okay, I want to get a pangolin and you're going to slit its throat in front of me and I'm going to eat it for dinner. And they'll pay like $250,000 to do that, even though they could be facing 10 years imprisonment. I mean, it's just not something that they see as really being an issue. So I think that in closing the gap on that end, as well as on the rural side, where we see that those educational programs might be more beneficial because the people are using this because they truly believe this is going to cure their possession, this is going to cure their deafness, this is going to cure their malaria. Whereas we know scientifically there are more proven effective results that don't require those pangolins. And I think that we do need to see that marrying of education and litigation.
My question is for Judah. Hey. So in Florida, FWC has constitutional authority to regulate nets. How do you see that litigation going to get them to change it?
Can I ask, what's FWC?
I'm so sorry, Florida Fish and Wildlife Conservation Commission. They have constitutional authority through our Florida Constitution to regulate both wild animals and fishing.
Yeah, that's a good question. FWC are incredibly important in Florida. You know how important Florida's fisheries are. We have a lot of the big ones, including redfish and shrimp. And FWC has pretty broad constitutional authority. So in terms of state-specific litigation, I think you'd need to see some sort of erosion of Florida administrative law deference first. I know that they're getting some new commissioners in now. I would hope that they would see things differently. I have sent one of them my article already. So, I mean, I would hope that they'll consider changing their requirements. In terms of the restrictions on net use, that's usually classified as a gear restriction. Norway has a lot of those, so there's certain nets that can't be used. My paper was more about how they use the nets, but I think in the end, the simplest solution is to remove minimum size restrictions. That mainly affects the recreational sector, but it would have an immediate impact. If you were going to really get to the commercial sector, you would need new rules surrounding nets, but it'd have to be part of a whole suite of laws like they have in the EU and Norway. So probably a bridge too far in the next couple of years. Good question, though.
Thank you all for your research and your presentations. I'm sorry I don't know your name, but the presentation about the pangolin, Ashley. So I just wanted to add maybe some comments that could potentially assist you. I haven't read your paper, but I did substantial research into the rhino trade. And I think one of the problems is we're always focusing on the people that are poaching and the people that are involved in the trafficking, but actually these people are very much at the bottom of the chain and they are completely dispensable. And you did touch on the fact and the issue of poverty, but these really are people, generally in South Africa particularly, who have absolutely nothing and they're doing this to feed their families out of desperation. So I think one of the solutions is to use the organized crime statutes to try and take down the criminal networks, because obviously these are highly organized criminal activities, and then also to focus on other human rights issues instead. So I don't think it's necessarily going to be just creating harsher punishment for the people that are at the very bottom of the chain, but really looking at this issue holistically and considering the human rights issues involved with it as well.
Yeah, absolutely. And that was something that I really wanted to incorporate more in my paper, because I actually spoke with a person who was part of HSUS and actually went into undercover with poachers and then would go into the actual place where they would hold all of the products for sale. And I absolutely agree with you. We need to punish those people who are distributing the products, those people who are really taking all of that money, the ones who serve as kind of the kingpin under the organization. And I think I would love to have something about analyzing this problem under the RICO statute or something like that. So I think that's an excellent point.
Hi. I guess for either international research or even research as far as local ordinances, what were your biggest obstacles in comparing different statutes and laws, and what was the thing that helped you most when doing your research?
I think for me, it was reaching out to professors who were skilled in international law. I personally love international law, but I can always learn more about it, and I don't personally know that much myself. So I think reaching out to those people who have more experience with it and can tell me, okay, here's what it means to be a party to a treaty. Here's where you can look for case law for international countries. That was really the biggest thing that helped me. And then, of course, I did a lot of research in my other piece on different state laws, and I tried to kind of mirror it like that and try to make charts and see okay, here's what this state does, here's what this state does, where are the similarities, where are the differences, that type of thing. So I think just trying to make it organized and kind of have graphs or graphics was really helpful for me.
I struggled mainly because with fisheries litigation, there's a lot of overlapping jurisdictions. So the people you sue, the agency you sue isn't necessarily the agency that wrote the regulations or aren't necessarily the ones that argued in favor of them. So actually figuring out when I was reading a case who the parties were and where they sat in terms of jurisdiction and the legislation kind of confused me for a bit, because I'm generally someone who just scans a case, gets the vibe, and then moves on. So actually having to sit down and read the cases and understand where all this came from was probably my biggest challenge.
I think finding a solution for the problem, because I think it's easy to, find what's wrong with an ordinance or what's wrong with the legislation, whatever it is, but finding a solution, but not only just a solution, but a feasible solution or something that can be actually carried on, or carried about. So for me, it was, I talked about those two main cases, and both of those lost, the plaintiffs lost. And so I think for me, it was trying to see how can you come up with a creative legal argument, but not only that it be creative, but that it work. And so for me, it was trying to come up with a proposal that would maybe actually come about and not just stay on, it sounds nice on paper, but is it feasible legally?
My next question is for Ashley. I was wondering if in your research you saw a movement maybe towards a lot of undercover investigative work to end these things. I know that there's been a lot for the rhinos specifically, and then in Florida we actually have undercover investigations into alligator egg stealing and illegal trafficking of alligators. So I wondered if you saw that as like a theme in a whole bunch of places, or if it's really isolated.
I haven't seen it as a theme specifically. The only other place that I've seen it is with Animal Crush videos. PETA had a cybercrime investigator in Texas that was able to locate producers of Animal Crush pornography, and that's really the only place that I've been able to see something like that in my research personally. That, as well as the individual I talked to who went undercover with HSUS, he specifically was there for rhino poaching, like you said. Unfortunately, I did not see anything like that, but I do think in the future we may start to see some programs like that arise, and I personally would be thrilled to see something like that because I think that they can be effective, and I think that it can be also effective in finding the kingpins, if you will, and finding who is actually purchasing these animals and their products.
Hi, this question is directed to Ashley. You mentioned that China is the biggest consumer when it comes to trafficked animal products, and that it has laws that exist that seek to protect endangered species, and yet we see that this problem is still happening. Is it when you're doing your research? Is it because there is lack of enforcement, or it's just laws that exist as draft and they haven't been adopted?
I think that it is mostly a lack of enforcement, partially due to bribery and corruption, because like I did mention earlier, there are a lot of very wealthy businessmen that will go out and eat pangolins because it's seen as a status symbol. So they can bribe off some of those officers. And at the same time, when we see these happening in traditional medicine uses in these small rural communities, there's nobody out there that's really policing them. It is China is vast, and there are a lot of extremely rural places, so it is difficult. And those are some similar issues that we see in a lot of African countries as well. They don't have the, what's the word I'm looking for? I guess like manpower to really get in there and like investigate these crimes specifically.
I'd also like to add that just from what you mentioned, that I think one of the issues is that, when it comes to Chinese people using these products for medicine purposes, it's more of, it's cultural. So for them, they don't see the need in conserving or protecting the animals, because it's more of culture than protecting animals.
Right, absolutely. And that's why I think educational programs are so important. Of course, because these are such well-ingrained traditions, I think that it's not necessarily about changing the culture as a whole, but just saying like, maybe these practices aren't necessarily effective to you. We can do other options, like here's how you can still maintain those cultural ties without breaking the law, I think is really what the goal of educational programs should be. Because it is such a delicate balance. We don't want to fully destroy it, but at the same time, these practices are not ecologically feasible for a lot of animal populations to continue to grow and thrive.
Thank you. Any others? Christina, did you have one? And we can probably wrap it up with that question.
Sure. I have a very easy question. I'm just interested to know how you each chose your topic. It seems like you're very invested in the issue, so I'm just curious if you had background in it or how you decided to focus on that.
So for me, I took an animal law and policy seminar, and we had to choose a topic to write on. And I had no idea, I'd never taken an animal law or anything related before. But I remembered a friend posting an article on Facebook about some monkey farms down in Hendry County, and I lived in Glades County, which we're neighbors. And so I started reading the articles about these monkeys being bred there, and I never heard about it. I asked people, nobody ever heard about it. And so through that article, I started doing a little bit of the research, and my professor said go for it, and that's how I started.
It's kind of hard for me to pinpoint one specific thing for me, but I think the really early on was just looking at the pet industry, just as somebody who used to work with a local mom and pop pet shop and seeing a lot of people, not necessarily in that store, but just in general with birds, and then having those birds have like these severe emotional problems. And I was thinking, okay, how does this happen? What is the root cause of this? And it kind of led me into, okay, this is wildlife trafficking. That's where this whole issue is. And actually at my job I worked as a criminal defense clerk, and one of our clients worked for HSUS many years ago and went undercover, and he was telling me about it. He gave me a copy of his book that he actually wrote about his experiences going undercover. And I was thinking, like, this happened so many years ago, but we're not really seeing any real changes. What can we do about this? And that's kind of what led me to ultimately settle on this topic.
So for me, it was an internship I did in 2011, 2012, when I was with the West Australian government, and it was pretty short, and I wrote a paper on it, and it only briefly mentioned minimum size restrictions. But while I was writing that paper, one of the meetings I had was with a couple of guys from the Department of Fisheries in Western Australia, and one of them had said that they could never get rid of minimum size restrictions because of the need to have an honest day's fish for an honest day's work. And I hated that. And it just ate away at me for years. So in 2016, when they released the working paper saying they were going through species by species and reassessing the use of minimum size restrictions, I thought, I wonder what they're doing in America.
Well, thank you so much. All of your presentations were wonderful, and I think we all look forward to seeing what you do from here. Putting you into practice.
Yes, thank you all so much. You are already professional speakers. I'm so impressed. I'm still nervous talking, and you guys handled it super well.